Simon.
Good afternoon, my lords. So at the point which I left, I was indicating to the court that there was access on that lower western road down to the public road. It was an access which itself was traveled by Justice Cottle, who indicates that in his judgment, having visited the locus in court. But I will draw the court's attention to the evidence. We look at page 66, the witness statement of Joseph Horsford. It begins, but I was born in the village of Liberty in the parish of St. Paul. My parents owned a portion of Mount Hill Estate, which at first registration under the new Registered Land Act is known as Parcel 26. It was down in paragraph 2 to indicate the last sentence. The lands of Parcel 26 border the public road leading to English Harbour just west of Glebe-land, which is Parcel 27, to the parish of St. Paul. And at paragraph 6, the access to and from Parcel 171 was along a path leading to the original point of entry where Parcel 26 abuts the public road west of the Glebe-land in St. Paul's parish. Of course, we do not have any survey plan which indicates Parcel 26. But what is quite clear is that Parcel 26 embodied the whole of the estate, or the lands of the estate, and this Parcel 26 which has been subdivided all along to create those various parcels which now appear on the plan. And if we turn to page 226, that at that stage, Mr. Horsford, who of course was representing himself, was cross-examining Mr. Oliver Joseph, surveyor. And then he got into a back and forth with the court. And you will see down towards the center where it says the court. Court says, Mr. Horsford, yes, I can see that the road now, the western road, it is now possible to drive all the way from the western road down to the main road. So I'm submitting that, looking at this evidence.
So that is the judge, I think, looking at an aerial photograph?
Yeah, that's the court, and he speaks of an aerial photograph, which Mr. Fuller then passes on to the court. I'm not too sure which is the aerial photograph when you look at that. But clearly, there has not been any disagreement that that western road finds itself or leads to the public road west of the Glebe by Bailey's Supermarket.
It may be physically possible to do that, but we're concerned with whether there's a legal right to do that. It may be physically possible to do that. The question is whether there's a legal right to do it.
Well, the point that which I wish to make or submit in respect of that is that in transferring or in the agreement between Mr. Horsford and Joanna Tobit, which appears on page 108, it is abundantly clear that the access to parcel 171 was given in respect of the Western Road. So that Western Road provided access to parcel 171. And I think we can logically say that that access would have been access from the public road.
And there was authority or the power to do that because the estate owned the road.
Owned the land and owned the roads. And Mr. Horsford himself was the
Administrator.
the administrator, the personal representative of the estate.
So he had the power in that capacity to grant the right of way over the whole of that area.
Over that area. That's respectfully my submission. Okay. And on that basis, he has made it very clear in the agreement, which of course Mr. Van Beek had insisted that this be done by letter. But what did not occur?
I understood that the other subdivisions had taken place before 2002.
Yes, there were a number of subdivisions. All of what we see there seem to have been taking place all along. Because Mr. Horsford himself got his parcel 171 in 1992. And I think we have agreed that Mr. William Horsford, the father, died in December of 1934. Letters of administration of his estate was given in 1969 and granted to his widow and his son, Joseph Horsford. So we can assume that from 1969, parcel 26 was being subdivided and transferred to different persons along those lines.
But it's your submission that that Lower Western Road, which on your submission carries on down to the public road, was always owned by the estate?
By the estate.
I don't follow that, I'm afraid. No. I mean, I understand that it was once upon a time owned by the estate.
But the whole of the lands there were the estate, parcel 26. And in subdividing, the estate also provided a road along the lands.
But no express rights of way that we know of.
No express rights.
So where is the evidence that there was a right of way down from parcel 193 to the public road?
Well, there seems to have been evidence which was given by the court below, because the judge himself has indicated, yes, that he has seen that.
Yeah, but seeing something physically on the ground doesn't...
Well, that was not the judge who actually went to the scene. That was...
Which case is it?
But then one of the judges did go to the scene, and the point which I wish to make is that the agreement itself clearly indicating that the vendor shall, prior to the completion date, clear and make usable by vehicles the lower road that provides access to the property, I would say speaks to itself. Because why would the purchaser be insisting to have that road cleared and to allow for vehicular access unless that road itself was leading to the public road?
Well, for their convenience.
Yes.
Right, but we've been over this point. I've asked you about this point before. Clause 7 does not say that the only right of access to the property shall be from the road.
No, it does not say the only. It only says the access. That road is what's being given as the access. So it specifies I would say the access. Here there are two roads, and it has specified one of the roads as being the access road. And we should bear in mind respectfully that the other access road belongs to the estate. So it would have to be specifically given.
I thought this access road, the lower access road, belongs to the estate.
Also belongs to the access, but the road below, in the agreement, Mr. Horsford makes it clear you have access to that road. The upper road, he has made no such concession.
No, but, well, the argument that you face is that there's an easement of necessity which arose either in 1992 or later, I think, in 2005.
I'm saying that there's no easement of necessity occurs, because at that point, the transfer is being made to Mr. Van Beek by virtue of the agreement with Joanna Tobit. So it's from Mr. Horsford, Joseph Horsford, to Van Beek, parcel 171.
If that's all he passes, he's passing a landlocked piece of land, isn't he?
Well, I am indicating that it is not landlocked, because when we look at the plan itself as well as the agreement, it clearly shows that there is access to the western road.
Well, physically, maybe, but legally, that's the question.
Well, unfortunately, it doesn't so state, nor is there any easement or restrictive, no indication as an encumbrance on the parcel itself.
I mean, what Clause 7 does is impose on Mr. Horsford an obligation to clear and make usable by vehicles that road. It doesn't confer any rights in respect of it. It describes the road as being the lower road that provides access to the property.
And when we look at
it does, but it's not granting any easement. Mr. Horsford personally couldn't grant an easement.
No, because the road belongs to the estate.
Yeah.
And then the lands themselves, which is transferring, that road borders the road.
Yes, but what you're saying is that that land, parcel 171, already had an easement to use the lower road.
Access.
A right.
Yes, to use that road.
Right to use that road.
That's right. That is right.
Now, when do you say that was attached to parcel 171?
Well, I would assume, for want of a better word, that it was done when Mr. Horsford himself transferred that land from the estate to himself, which would have been as way back as 1993.
Yeah, it must have been then, if I mustn't have.
Because if not, he would not have had access himself. So I would say as far back as 1993.
But an easement of necessity has to be over land which the person with the benefit of the easement will be legally entitled to use.
Indeed. And the person legally entitled at that stage would have been Mr. Van Beek, because it's been transferred
we're
to
talking
Van
about
Beek.
1992, 1993.
Well, 1992-93 would be.
So it would have been the estate, you
It
say.
would have been the estate.
But these parcels of land had already been sold. It was no longer just the one parcel 26.
No. 26 had already begun to be subdivided, and it was a process that was ongoing. We do not have any evidence in terms of when the various subdivisions took place.
But I think
it seems to have been an ongoing process.
But we know that at least some had occurred before.
Yes, maybe it's called.
Yeah. Right. Thank you.
So if we go back to 1992/1993, it's your so we've then got a position, as I understand it, where the estate is transferring to Mr. Horsford personally parcel 171.
Yes, my lord.
And the question is, what are the rights of way that attach, that might be regarded as attaching to 171? And as I understand it, your submission would be that because there is at that point the grant of an easement over the lower Western Road, then there's no need for any easement over the upper Eastern Road. Is that right?
That's respectfully what I'm saying. Although the land, both the eastern and the western road, borders the land, the easement is really given in respect of the western road. And it's on that basis that Mr. Horsford, in agreeing to sell that parcel 171 to Joanna Tobit, makes mention of that access to that western road.
So there's no question of an easement of necessity back in 1992-93 because there's always the access via the lower Western Road.
Yes. That was the ground.
Surely that argument only works if there is not just a right to use the road marked green, the lower Western Road, but that there is also a right of way over the land running from parcel 2, I'm looking at page 614, 260 down through 225, 226 and so on to 229. Because otherwise...
Yes, indeed.
Otherwise...
But that's in the estate.
You're still landlocked. Well, no, I thought we'd established that it was not in the estate.
It would still be landlocked.
Yeah.
If otherwise. So that right, that access gave way to the roads going right down to the public road.
But I understood your answers to Lord Richard's questions to involve acceptance that by 1992-1993, the estate had already sold off at least some of those parcels of land, so that the estate did not have in its power, as property owner, the ability to grant anyone rights of access right the way down to the public highway from that, from the end of the Green Road.
No, it did, because that right of access was part of the estate. And what the estate did when it subdivided...
I thought you accepted the answer to Lord Richards that the estate had, by 1992-93, already been subdivided.
But
the roads were there.
But as I understand it, your submission is, but they kept the road.
They kept the road was there.
Right.
It was their road.
Yes.
Or that roadway was there. So whilst you're subdividing, you're also having that road there which gave access to all of those various parcels.
Right, but if you had sold off the property rights to 223, 225 and so on, what creates the right of way?
But I'm not suggesting that the property... I'm suggesting that in subdividing, creating those various sub-parcels, that road itself was kept in the lands of the estate. So it was not, everything was not transferred.
Well, where's the evidence of this?
I mean,
you're now saying that the parcels were transferred, but not the road alongside.
Not the road alongside, but there's the road alongside.
We have no evidence of this.
Indeed, it's contrary to 614, isn't it? Because 614 shows clearly where roads exist, presumably as separate property, but does not show such roads running down the western side of 223, 225, 226, 227, which is what we're debating.
That's where your plan comes.
Yes, that plan itself is deficient in that respect. And that is why I then indicated to the court that the plan which I then produced dealt with the right of way given to those various parcels, surely shows the road alongside parcel 17 going up.
It doesn't say anything about who owns it.
Does it say anything about it?
It doesn't actually say it's a separate parcel, and it doesn't say who owns it.
No, it doesn't, but it's not a public road.
No.
The lands there were private lands. The lands belonged to the estate. All of was parcel 26. So that when the subdivisions were being taken, that road was also demarcated.
The trouble is there's
no evidence.
Right.
That is the trouble. But that is why I pointed out to the court that the court itself, following the cross-examination by Mr. Horsford, Oliver Joseph, clearly indicates, and they did so from an aerial map, because here is the court saying, I can see that road now. The western road, it is now possible to drive all the way from the western road down to the main road. And it is not a public road. So therefore it has to be a road which is a private road on private property.
And it still
giving the
belongs...
right of access.
Who does it now belong to?
It still is.
It's the estate?
Estate. Still is the estate.
So it was in 1992 the estates, and it still is?
It still is.
But, I mean, it would have to be a separate parcel.
Like the Eastern Road.
The Eastern Road, well, that Eastern Road was created, well, I agree, but that was done, that normally is done on application to the registrar, because the Eastern Road was not always named or pointed out as parcel 281. Right. It's only subsequent, during the process of this court matter, that it was given that 281 number.
All right, well, by illustration of that, I mean, the continuation, I've got the colour version, so immediately above parcels 291 to 298, 291 and 292, the road goes, well, the road goes from being red to being green. So that's the end of, as I understand it, the end, what's shown in our plan as red is parcel 281.
No, may I also indicate that the colouring was done by my learned friend?
All right, but I'm right in my understanding, am I, that parcel 281 finishes at the northern end of parcels 291, 292.
No, it continues up to 239. Sorry. I'm not even too sure on that. I don't know if my little friend can assist along with
Well, sorry.
It ends at 291, 292. That's the registration of the...
For parcel 281.
The 281, yes.
Thank you. So if you then continue along the road in a northwesterly direction, shown green on our plans, it then comes to parcel 239 and then turns a sharp corner and comes down the lower road. Is that actually, has that got a parcel number at all, the road?
No, it does not.
No, all right.
The rest of the road does not have a parcel number. It doesn't. And as I indicated, the parcel number was only given during the course of those proceedings.
Yes.
That the respondent seemed to have made the application to get that parcel number assigned. And I think I do have... Because it was also granted, yes. So it was done during that process.
Yes. Yes. So the fact it doesn't have a parcel number the fact that a piece of land does not have a parcel number does not mean it can't be owned by
the particular party, yes.
No, that's
yes.
As it is here in this country too. Right.
Because you will note it on page 630 with that survey plan that I presented to the court. It says road, but it doesn't mention a parcel number either. And even the right of way on the right, there's no parcel number. So that is how apparently so the fact that it does not have a parcel number does not actually take away from the fact that it belongs to the estate as part and parcel of the original parcel 26. Now, following on the agreement with Joanna Tobit, parcel 171 was then subdivided to create parcel 217 and parcel 218. And that subdivision took place before parcel 171 was actually transferred from Joseph Horsford. And I would direct the court's attention to pages 96 and 97. Which are letters, one from Joanna Tobit and one from Paul Van Beek, which clearly indicate.
Forgive me, the page number again.
Oh, sorry, page 96 and 97. And that clearly indicates that the subdivision was done by Paul Van Beek.
Sorry. Yes, sir.
If you look at page 96, the third paragraph, writing, of course, to Mr. Horsford, I have since subdivided this land into plots 217 and 218. Please see enclosed drawing.
So is this slightly chopped off at the side? Is it a
Yes,
piece of
it is.
land named plot 171? Is that what it should say?
It is kind of chopped up. But you can see it says subdivided this land. And please see enclosed. So it looks like it's just one letter from each page. But it's plot 171. And at page 97,
But is this is signed by Joanna Tobit?
Joanna Tobit.
But she hadn't taken a transfer of the land. And,
Transfer has not taken place.
no, and so how can she subdivide it?
She had an agreement for the land to be put for her to purchase the land. Because the purchase agreement was done in January 31, 2002.
I mean, at this stage, I'm not sure what the date of this letter is, by the way.
No, there's no date on it.
But at this stage, your client is still
The registered proprietor of the land.
So, was his consent needed to the subdivision into the two parcels?
It appears from the evidence that the Registrar of Lands has given that up to that date, there was no requirement for the registered proprietor to have signed or give a written consent.
But if he had to, I mean, if it was needed, he would have to give it, wouldn't he?
Yes, in fact, today he has to.
Well, he would have had to then, if it was required, because the contract of sale to Joanna Tobit, your client had been fully paid, I think.
Yes, been
So
fully paid.
he was the bare nominee for Ms. Tobit.
For Ms. Tobit.
So if he was directed to sign a subdivision document, he would have to sign it.
But he claims he did not.
Well, it doesn't really matter.
Doesn't, that's what I want to come to. It really doesn't matter. And if you look at page 97, where there is a formal letter dated 10th of May 2005, that letter comes from Paul Van Beek. Where he writes, this letter is to inform you that eventually I have managed to subdivide plot 171 on Monks Hill, previously purchased from yourself, into two plots, 217 and 218. Doesn't mention anything about consent. He says he has managed to do so. And I'm selling plot 218 to Clement Mark James Bridge and Patricia Margaret Bridge.
And he then asks your client, to, Mr. Fuller, to enable the transfer.
To enable the transfer.
Yeah.
So that was parcel 218. And then 217 was then transferred.
Sorry, 217, did you say?
Yes, it was the 171 was subdivided to 217 and 218.
I see, sorry.
And it's important to note that the subdivision allowed for the lands, both parcels, subdivisions, to be bordered by both the western and the eastern road. Now, the transfer occurred of both parcels on the same instrument of transfer. My client's signature appears as a transferor.
And do you have a bundle reference for that?
Page 62. Reference for that. I will have it here in a short while. Page 472.
Thank you.
Yes, the instrument of transfer. Now, Mr. Horsford has indicated, and I think he went along, stating that he is not the one who signed it, he was not aware of the transfer because he was not, the date which is on the transfer instrument, he was actually in England attending a hearing before the Privy Council. But it is immaterial to the issues in this matter. The important point is that the transfer took place, and in fact, the agreement for sale also clearly indicated that Joanna Tobit could have directed that the lands be transferred as she would wish. And Mr. Van Beek was her living partner. So I don't think there's any much issue in respect of that legally. Now, on October 12, 2006, the transfer to Mr. Croft took place. And I would respectfully submit that the transfer of parcel 217 to Mr. Croft also gave him the right of access to the Western Road. Because 217 was simply a subdivision of parcel 171. So the transfer took place on October 12, 2006, and it was registered on December 1, 2006. Mr. Croft, the appellant, mutated parcel 217 in January of 2017, creating parcel 291 and 292. So he does that about 8 years later. He does his mutation. But in September 2008, he sues Mr. Horsford. At that time, he was in the midst of building on parcel 217. And his claim in that suit was that the roads, both the western and the eastern road, were public roads, and that he was entitled to unrestricted passage by foot or by motor vehicle. The High Court found for him and declared that the roads were public roads. However, on appeal, the Court of Appeal allowed Mr. Croft's appeal and declared that the roads were private roads.
Mr. Horsford's appeal.
Mr. Horsford, yes. That the roads were private roads and not public roads. And they further held that Mr. Croft did not have a right of access over the eastern road, since that had not been granted to him. So that was the Court of Appeal decision in September of 2011. And it is in June 2012 that Mr. Horsford created parcel 281. So before June 2012, that was just an open roadway. We did not have any parcel number to it. But following that legal battle, Mr. Horsford decided to have part of that land be made parcel 281, covering an area of 0.49 acres.
And he did that in his capacity as administrator?
As administrator of the estate, because it was taken from parcel 280, which was in the name of the estate. In December of 2012, Mr. Horsford then sues Mr. Croft in light of the fact that Mr. Croft continued to use the Upper Eastern Road, parcel 281, without his consent, without his permission. Following the Court of Appeal's order that the road was a private road and Mr. Croft did not have a right of access. Now, it is important for the court to note Mr. Croft's construction on parcel 171 before he had subdivided it. And I take your lordships to page 419 of the bundle. that the construction of the residence as well as the cottage by Mr. Croft was on the upper part of parcel 171 adjoining the
217.
adjoining 281 the road.
I beg your pardon, 281.
Yes, adjoining 281 the road. So that's where he decided to build, up and not down. And you'll notice his gate entrance for access is to parcel 281. And there is no access from the lower, if I'm mixing western or eastern, western road. And in fact, he built a wall right on his boundary line.
At the bottom.
At the bottom.
And you say this is all his choice?
That was his choice. That is what I'm respectfully submitting. That was his choice. Because at that stage, he knew very well that neither the western nor the eastern road were public roads. He knew of the court decision that he had no right of access on parcel 281, the eastern road. That his right of access was on the western road, and that Mr. Horsford was willing to give him permission to use the eastern road on condition that he paid a certain fee.
Can I just go back to why you submit that Mr. Croft had rights over, that is, an easement over the lower western road? At what point did that actually occur on your submission?
Let us remember that his parcel was a sub 217, was a subdivision of parcel 171.
Yeah.
And parcel 1771
Yep.
had been given the access to the lower western road.
So that was during Van Beek's
During Van Beek's, yes.
expressly given access
It
to
was
the lower road.
expressly given.
And how could Horsford do that, given that the access road belonged to the estate?
Well, he did so in his capacity as personal representative of the estate.
So he
Because
was
he was a trustee of the estate.
selling 171,
Which he owned personally.
which he owned personally, but he was giving rights in his capacity as administrator.
Yes, well, these were rights which when the 171 was transferred to him, he had obtained. Because he didn't just simply obtain parcel 171 without right of access. When he bought 171 from the estate, he was given right of access to that western road.
Oh, right. So he's passing on a right that he was expressly given.
So he is passing on a right which was expressly given, and expressly gave that right under agreement for sale with Joanna Tobin. So that when Mr. Van Beek sold to Mr. Croft, he could only sell to Mr. Croft what he had, which was the access to the lower western road.
Do we have any documents which show that when Mr. Horsford bought 171 from the estate, he was expressly given access by the western road?
Didn't see any such document on him, on the record.
So how do we know that? How do we know that that's right?
On the basis of the findings of the court.
Well, on what
The courts themselves have declared.
on what basis was the court able to come to that conclusion?
I would think based on the evidence that was led by the parties.
Well, which evidence?
Well, Mr. Horsford's evidence, as I indicated
Did
earlier.
Mr. Horsford say that when he bought 171 from the estate, he was expressly given access by the Western Road?
Well, I have not seen that, to be honest. But he says on page 66, in his witness statement,
Yes.
it just says in paragraph 6, the access to and from 171 was along a path leading to the original point of entry, where parcel 26 abuts the public road west of the Glebe in St. Paul's Parish. Follow.
That's as
That
far
is
as
where
it is.
he indicates that he has that right of access.
Thank you.
What page is that?
Page 66.
Thank you.
And this is the paragraph that's
That's paragraph 6.
referred to in the Court of Appeal.
Yes, I think the Court of Appeal referred to 7 and 8, but that
Same.
involves a reference back. It's an obvious slip in 7 to paragraph 6 above, I think.
So the Court of Appeal has accepted that.
Which paragraph? Sorry, just give me the paragraph from the Court of Appeal.
19.
19 again, yes.
I think it is.
Paragraph 6. The record is really full of evidence. The court there.
Yes, I mean, he doesn't, I mean, the Court of Appeal doesn't there say that there was an express grant of a right
No,
of way.
it does not.
They deduce it from Mr. Horsford's evidence that he used he used the path west of the Glebe to gain access to the public road.
And I think they would have taken into consideration the fact too that Mr. Horsford not only owned 171, but he also was the administrator of the estate, who owned the western and eastern.
They're looking at 1993 then, I think, when the estate owned the parcel 171 and whatever it still owned.
That is indeed so.
Yeah.
So there has been no issue. In fact, there has been no issue by Mr. Croft that he did not have access through the Western Road. I think his whole issue is that access to the Eastern Road was more convenient for him. And the reason why it was more convenient is because of the way that he had constructed his residence.
Hold on. Access to the upper road.
And if we look at the judgment of Justice Cottle, where this appeal arises from the Court of Appeals overturning Justice Cottle's judgment, at page 509, paragraph 9 and 10. It says the facts of this matter are not in dispute. The claimant owns parcel 281. The first defendant uses parcel 281 as his means of accessing his home. The claimant, and in that case, of course, the claimant would have been Mr. Horsford as administrator. The claimant does not consent to this. On the face of the cadastral survey maps, the first defendant's land is bounded by 2 roads, and it appears that he can access his property by means of the lower or western road. The court visited the locus in quo. It was at once patent that the access via the western road was only apparent, but far from real. And the reason? He continues. The topography rendered it extremely difficult to build a driveway from this road onto the first defendant's property. But more crucially, the claimant at the locus in quo explained that the western road is also his private property and the first defendant would require his permission to use it. At the entrance of this road, the claimant has constructed a gate which he can lock at any time, effectively preventing access along this road to the first defendant's property. The effect of all of this is that the first defendant is landlocked. He cannot access his home unless he passes along one of the roads which from his western and eastern boundaries, I guess, which lie.
Which form, I think.
Oh, yes.
Form, not from.
From his western and eastern boundaries. Both those roads are owned by the claimant. This is the epitome of an easement by necessity. And we respectfully submit that Mr. Croft made the choice of constructing his residence towards the upper eastern road, parcel 281, rather than towards the lower western road. Constructed a wall at the boundary of the lower western road, and as the court, the Justice Cottle indicated, the topography will make it difficult for a driveway. Not impossible, but difficult.
He says extremely difficult in paragraph 10.
He says extremely difficult.
And then in paragraph 15, he says there is in fact no other access apart from the upper road.
He wrong said that there was no other access.
Well, that's what he found.
There was no other access because there was a wall, a boundary wall that Mr. Croft.
He doesn't even mention.
He does not even mention it.
He doesn't. He's not. So far as we know, taken that into account.
He has not taken that into consideration whatsoever.
So your submission is that when Mr. Croft bought the property, he had the same rights as Van Burke to use the estate's lower western road, and that there can be no question about any easement of necessity, because at that point he can build where he likes.
Yes.
On his property.
Indeed.
He could have built right down by the western road. He's chosen to build at the top of the road, but he's only got rights to the bottom road. And that's, in a sense, his problem. That's your submission.
That respectfully is my submission. And he has created his own problem. Because he was very much aware, before he began his construction, that his right of access was to the lower western road. And that's why he sought initially to have both roads declared public roads. And he was unsuccessful at the Court of Appeal and did not appeal any further. So Mr. Horsford finds himself with the Court of Appeal declaring that both roads are private roads, which conforms with his position that they belong to the estate. He has given permission for the lower western road to be utilized, but Mr. Croft, in defiance, continues to use the Lower Eastern Road and then sues.
Could I ask you a question about paragraph 10 in Justice Cottle's judgment again?
Justice Cottle.
Which is where he records that, I think, where he says the claimant at the locus in quo means that the claimant gave explanations when they had the site visit. And he says, he explained the Western Road is also his private property. The first defendant would require his permission to use it, and that he has a lock, a gate that he can lock at any time. Now, might it be said that that is difficult to square with any acceptance by Mr. Horsford that there is a right of access, in legal terms, running from the end of the road marked green from lot 193 down to the public highway? Because if he's maintaining that he can lock the gate and prevent access to the Lower Western Road from that direction, that would be difficult to square with there being a right of access right up to that point.
I understand your Lordship's point, but at no point in time was it indicated that that gate was locked and there was access was denied.
No, but
none at all. So
no, but Mr. Horsford was maintaining that he would be entitled to do that.
I don't think there's any evidence where Mr. Horsford had maintained that he was entitled so to do.
Well, the judge records that he says he had explained that the Western Road is also his private property, and the first defendant would require his permission to use it. And then he explains that he's got a lock in place that he can, a gate in place that he can lock at any time.
But the permission was already granted to Van Beek, so it was there.
But he's denying the permission here.
No, he's not. He never did. The permission that he only denied was the permission to use the Upper Eastern Road.
Well, I'm sorry, but I think you must read to yourself the third and fourth lines of paragraph 10 of Mr. Justice Cottle's judgment. Therefore, the third to fifth.
It says at the entrance of this road, the claimant has constructed a gate.
Well, the sentence before, but more crucially.
But more crucially, the claimant at the locus in quo explained that the Western Road is also his private property, and the first defendant would require his permission to use it.
And then he's constructed a gate which he can lock
at any time, effectively preventing access. It is there, and it reads as though there is some obstacle created by Mr. Horsford for him to use that road. But in truth and in fact, that was not the situation, and that is why the Court of Appeal itself threw that out.
Does the Court of Appeal refer to this?
I think the Court of Appeal from page 3 to 6.
Well, paragraph 20, the Court of Appeal refers to...
Yeah, 19 and 20.
Paragraph 10, obviously.
Yes, so he refers to it there, and then...
So it begins by saying it is not in dispute that by agreement dated 31st January 2002, Joseph Horsford in his personal capacity transferred 171 to Joanna Turbidge. The evidence is that in 1993, when parcel 171 was transferred and registered to Joseph Horsford, he used as access to the public road a path west of the glebe land, the Western Road. So that parcel 171 enjoyed a right-of-way over the lower or Western Road. An express easement was granted over this road to Mr. Bitt on the transfer of parcel 171 to her. There is no evidence in the record of parcel 171 ever enjoying an easement or right-of-way over the upper or eastern road. 20. The learned trial judge found
I think we have read it, yes.
yes.
I mean, it might be said that the critical point seems to be paragraph 22, where the Court of Appeal says there was no finding by the trial judge that the lower road did not in fact lead to the public road, but they don't then focus on what might be the significance of what Mr. Horsford had said at the locus in quo in relation to his ability to deny access to the Western Road, in terms of what rights might exist from the Western Road down to the public highway.
And, I would think at paragraph 19.
And you understand the point I'm pressing you with, Mr. Simon, so that you can deal with it. It seems very odd that Mr. Horsford would be denying a right even of access into the lower road if he's maintaining that there is a right-of-way for the benefit of 217 and 218 right up from the public highway.
Indeed.
Up to that point. Do you want to say anything further about that?
No, I'm accepting that. Because he's made it quite clear that from the Western Road, you have access to the public road. Going right down through the Glib, which is not too far from Bailey's supermarket. So that access is there and has always been there. The only access Mr. Horsford has been denying is the access to parcel 281, the Upper Eastern Road. That is what he has been sticking to. I take your lordships to my submissions at page 622. But there I deal with the survey map.
So which paragraph are you?
At paragraph 23 and 24.
Thank you.
And I have indicated that the survey map, which appears at page 640 from my learned friends' submissions, does not show the completion of the road, or I shouldn't say completion, but does not show the road from parcel 219 down to parcel 228. And I'm submitting that this has existed, and it is on this basis that I have referred the court to the survey plan, a map of 6 at page 630. It does show that there is a road as well as a right-of-way, which is a continuation of the Lower Western Road. friend's argument is that there is an easement of necessity for use of the Upper Eastern Road, parcel 281. The Court of Appeal in its judgment has made it very clear that the easement of necessity cannot exist in those circumstances because both the dominant and servient element must be in the hands of the vendor for there to be an easement of necessity. So that at no point in time was the Upper Eastern Road or parcel 281 a servient element. Sorry, yes, a servient element of parcel 171 or Mr. Croft's now 292 and 293. I think he has now subdivided the lands into. And 292. And the court should note that that mutation creating those two parcels, one on which the cottage stands and one on the other on which his residence stands, was not done until January of 2017. So at no point in time at all did Mr. Croft have any real relationship with Mr. Horsford, either in his personal capacity or in his capacity as the administrator of the estate in respect of the lands that he currently owns. Mr. Horsford was not part and parcel of any of that transaction that was between Mr. Croft and Mr. Van Beek. And clearly Mr. Van Beek could not give him any rights to parcel 281, Upper Eastern Road, because that never belonged to Mr. Van Beek, nor had Mr. Van Beek obtained any rights over parcel 281 from Mr. Horsford. So we respectfully submit in those circumstances, there is no right to an easement of necessity, nor is there an implied grant of access, because Mr. Croft has himself created the barrier by building his wall on the boundaries of the Lower Western Road. So he has himself cut himself out of the access to that road which has been given. And now by as of right access to the Upper Eastern Road. The only other point, well, two other points which I wish to make. Is that the issue that the respondent has made in respect of him not signing the transfer to Mr. Van Beek is neither here nor there in respect of this matter. The real issues on this appeal. And he has raised his claim that he is not aware because, one, he says, signed a transfer to Joanna Tobit upon receipt of the funds, the consideration for the monies.
I mean, this has all been the subject of findings against your client, hasn't it?
Yes, yes.
Which are not the subject.
I don't think that is
So I don't
subject
think
here.
you can.
Thank you, Lord. So I think even my clients seeking to sue the Attorney General and the Registrar of Lands to get the two subdivisions back into one parcel was not a sensible, let me put it that way, application to the court, which he has lost. But you will notice that my client has been basically representing himself throughout the whole process. So I don't think he has had really the benefit of legal assistance along those lines. But that again, I would submit, does not address any of the issues before the court. I know my learned friend is seeking to indicate that because of that actions by my client, that it shows or reveals a certain amount of dishonesty in respect of his conduct, and that should be taken into consideration. But I'd respectfully say to the court that this is really neither here nor there in respect of the issues which are before the court. And my client may well have been misguided in respect of those matters. The final matter is the issue of the encroachment. And paragraphs 18, I draw your court's attention to page 625 of the record. My submissions. Paragraph 31, page 549. Sorry, page 625. Page 117. I think there is evidence, I'm just trying to get it, where Mr. Croft himself has admitted that there is an encroachment. If we look at page 80, I believe I've made reference to page . Yes. Page 80, we do have the surveyor's plan in respect of the land. That is also appears on page 117.
Sorry, who's surveyor?
Sorry.
Is this? This is S. Oliver Joseph. Whose witness was he?
Mr. Horsford, yes.
But we do have evidence. I'm just trying to see. What did I do? He has actually admitted that there was an encroachment.
Well, didn't the Court of Appeal say that?
Yes, and the Court of Appeal did agree with that. In fact, I have indicated paragraph 18 of the statement of claim, where he says is denied. That is in his defense. The said wall and roof do not encroach over the claimant's land. The land in question is not the claimant's land, but is land belonging to the estate of William Horsford, deceased. And that land he's referring to is the Upper Eastern Road, where the wall and the roof have encroached. So he's accepting here that land does not belong to Mr. Horsford in his personal capacity, which we agree, but it certainly belongs to the estate of William Horsford, deceased.
I think it's the Court of Appeal, paragraph 28.
The road is.
Where they say he has pleaded affirmatively that the land belongs to the estate of William Horsford,
indeed,
deceased.
And he says so in his defence.
And paragraph 30 again, yeah.
Yes. And it's an encroachment which I'm concerned it could be a matter for damages. It's not a matter which needs to go back to the registrar, because it's not a boundary dispute, which is what the Registered Land Act would be addressing. Damages, as the Court of Appeal has indicated, would be quite a sufficient remedy. The Court of Appeal does say so. Look at beginning at page 327.
And I think the Court of Appeal awards damages in lieu of an injunction.
Yes,
in respect of that.
indeed, Miller. And I have no problems at all in respect of that.
So does the quantum of the damages remain to be determined?
To assessed. In fact, the Court of Appeal does say the damages to be assessed in the court below by a judge or master.
And that hasn't happened yet?
That has not happened yet.
Okay.
Because that has been stayed pending the determination by this Honourable Court. You will see at paragraph 24, the Court of Appeal, that's at page 327, repeats the averment of the respondent at paragraph 18 of his statement of claim. Paragraph 25, the appellant therefore sought damages for the continuing trespass and an injunction in the court below. And at paragraph 26, in paragraph 9 of his defense and counterclaim, Mr. Croft denied paragraph 18 of the statement of claim and averred that the wall and roof did not encroach over the claimant's land. He stated that the land in question is not the claimant's land, but is land belonging to the estate of William Horsford, deceased. So that there is an encroachment, he accepts. What he just does say is that it is not an encroachment in respect of Mr. Horsford's land in his personal capacity, but that of the estate. I think in those circumstances, damages would be an adequate remedy. It should be assessed by the master or the judge, court below. That please you, my lord, is the extent of my submissions, unless there were questions.
Thank you very much, Mr. Simon.
Can I deal in reply, first of all, with the lands below parcel 193 and the ownership of those lands?
Yes.
Because there was no evidence from Mr. Horsford at all at the trial that the estate still owned the roads. And one starts at page 287, where Mr. Croft gave evidence about parcels 209 and parcels 217 belonging to the estate of, I believe it's Joseph Edwards, deceased, and Mr. O'Garrow.
Sorry, bear with us just a moment.
So it's 287, first of all.
So which parcels are you talking about?
We're talking about the roads below parcel 293. That's the route to the highway from the Lower Western Road. My learned friend said that these were still owned by the estate.
Below 193, or
Yes.
Yes.
below 193.
193, I do apologise.
Yes.
Said that they were owned by the estate, but there was no evidence about that at all in the court below, in the sense that what the evidence was that parcel 181 was a remainder of parcel 26. But there is a mention, so at page 287...
Sorry, you said parcel 181 just then, I think.
Sorry, did I say parcel? I do 281. I do apologise. So in the court below, Mr. Horsford's evidence was that parcel 181 was a remainder of parcel.
Sorry, I'm just getting. You're losing.
281 was a remainder.
Sorry, well, where is 281?
That's the road.
Oh, forgive me. Yes, the road. Sorry, I thought we were. Oh, sorry. I misunderstand.
And so what I'm talking about now is from parcel 193, this is the Lower Western Road,
Yes.
and the route to the public road.
Yes.
Right.
And so at page 287, you have Mr. Croft giving evidence about crossing the land of strangers, parcels 209 and parcel 217, and giving evidence that they belong to 209 to Mr. Agarrow and parcel 217 to the estate of Edward Joseph, deceased.
So this is the evidence of Mr. Croft, is that right?
That's the evidence of Mr. Croft.
And which is 209? I'm just trying to see where that is.
209 is where 303 and 302
Oh, yes, you did tell us.
See,
Yes.
the parent parcel is 209. And then when you come down to page 288, Mr. Horsford intervenes and he accepts O'Garrow and Joseph, and it's line 19 of page 288. The judge asks, what about them? You know, those lands of the same overall estate, and the roads have been established over the years, since I was a boy. O'Garrow was using their land and Joseph using their land on the other side. And it says most of it, and I can't read because the court stamp is over it, there is no part, and then he goes on to say at 25, there is no passing over or by. But what he did not say was that the roads belong to the estate, and that would have been a perfect opportunity to do so, but he doesn't say that. And so my submission is there is no evidence that the estate owned back in 1992 or in 2002 or 2005.
So he, at the bottom of 288, Mr. Horsford seems to be saying that since he was a boy, O'Garrow and Joseph were using their lands.
Yes, but he doesn't. He does not say it's the land of the estate.
No, but possibly the significance of that is that by 1992 or 1993, already the ownership of plots 209 and 17 had passed away from the estate.
Yes. And so the simple point and the short point is that there was no evidence before the court that the roads below 193 were owned by the estate.
So, yeah, all right. O'Garrow always owned 209, did he, so far as...
Yes.
Right.
And it looks like the estate of Edward Joseph deceased always owned parcel 217 as well.
Maybe that answered my question. I had understood that at one stage the estate of Horsford owned all this area of land.
Well, I'm not sure about the area, but it was...
Sorry, running from 228, 229 and right the way through.
There's no evidence of that at all.
Is it the case that it owned most of?
It owned something like 30 acres, But where that went precisely, where the 30 acres was precisely,
That doesn't sound very much.
No.
Yeah, 30. Oh, okay, but we don't know where. Okay, right.
But the point I'm making is there's no evidence that the road below 193 and then the track to the public road is owned by the estate. And as you can see at page 288, Mr. Horsford didn't say that.
No, but he wasn't. I don't know whether he's been asked that question.
Well, if one goes above to page 287,
Yeah.
one sees that the discussion is about crossing the land of strangers. And so at line 2 on page 287, Mr. Croft, can you tell us what 2 parcels of private land you have to cross if you use the Western Road? And then I think he eventually hears and he says, I don't know, I think it's 209. And Joseph is another number I forget. Then the court says, hold on there, they're owned by who? And then it goes down to line 23 on 287, plot 17, that belongs to John Edward Joseph, deceased. And then on page 288, and at line 5, yes, who owns that? That's in relation to plot 209, and then he says O'Garrow.
I see.
And then at line 14, Mr. Horsford interjects and says, my lord, would I be entitled to say something at this point? And then at line 20, he then says, you know, those lands are the same overall state and the roads have been established over the years. Since I was a boy, O'Garrow was using their land and Joseph using their lands on this date. There is no passing over, passing by. And then the court, at page 289, line 1, the court, what the point that Mr. Croft is trying to make is saying that the Western Road, that's not in fact, yes, would lead him over those lands. Not at all, never do so. Are you saying that the Western Road does not lead over those? No, I don't interfere with them at all. But that's the only route on the map. But the point is, Mr. Horsford did not say the estate owned the roads below section 193. It appeared to be ownership between O'Garrow and the estate of John Edward Joseph, deceased, and then they used, Mr. Horsford used the land, but it wasn't a question of the land being his.
I think perhaps at page 630, although I'm nervous about relying too much on this document, one sees that in relation to plot 17, because page 630 is showing the lower portion of what we've been talking about.
Yes.
And I think that the number in 17 in a round circle to the left is indicating that that's plot 17.
Yes.
And we can see that the road and the right-of-way seem to be over that land.
Yes, created in 2007.
The map, the plan.
The map was created in 2007 to create a right-of-way over those lands in 2007. And
We weren't clear about that, whether the printed words right-of-way already existed, and that this map was to create in 2007 a new right-of-way to the right, to the east.
And that's a difficulty because we don't have Mr. Eto Kentish, the surveyor who drew it, drew the map. We don't have him present to assist the court. And this evidence wasn't before either the High Court or indeed the Court of Appeal. It's a document that my learned friend readily admits he obtained from the Land Registry. But there was no evidence about it at all in the court below, no finding by the Court of Appeal about it, no finding by the High Court about it. And so my submission is that little, if in fact no weight, can be placed on this map. It was never in evidence, not part of the record. It's a document that my learned friend produces to assist the board, but as such, it is not evidence before the board, and no application has been put in to adduce fresh evidence. And so what the board is left with is, as my learned friend readily admits, the cadastral at 614, and he accepts that's an official survey map. And in any event, I just want to go back to 630 just for one moment, because one sees the smaller map on the side.
Yeah.
And that deals with, sorry, I've got to get to that. That deals with the creation of a right-of-way, as in the title suggests, from... Sorry, I've got to get the map again. I do apologise. My system is slow. Oh, I might be able to get it. It deals with the creation of a right-of-way over parcels, and it's at the title 224, 225, 226, 227, 229 over parcel 217. That's what it's dealing with. It's dealing with a right-of-way, because if one looks back to 614...
Well, just before we move away, I think that does tend to bear out that, as Lord Kitchen observed earlier on, the right-of-way being created by this document is that marked in manuscript to the right of the larger plan, because it's only that right-of-way which is over the parcels identified.
Yes, but the point is, there is no evidence of a right-of-way existing prior to this date. In any event, one has to go back to 1992, 1993 to see whether or not there was a grant of any right of access to parcels, to parcel 171 by the estate. And there is no evidence at that stage of a grant of any right of access. So Mr. Horsford, in his personal capacity, could have only had a right of access by way of an easement by necessity. That easement by necessity is not destroyed by virtue of the fact that the land is transferred to Paul Van Beek. Neither is it destroyed by virtue of the sale agreement with Joanna Tobbett. And the fact that no right-of-way is registered at all in the land registry seems to support the appellant's argument that there, therefore, must be an easement by necessity. So far as Clause 7 is concerned, my Lord, I don't read Clause 7 as, in terms, granting an easement at all. And it's absolutely clear from the site view that neither did Mr. Horsford consider an easement had been granted. And he tells the judge in terms that before Mr. Croft can use that road, he must have his permission.
Can I ask, do we have any information about the dates on which parcels 160, 216, 143, 254, 253, 126, 104 and 100 were created?
No.
All right.
No, there's no evidence in the Court of Law, or indeed no submissions made in the Court of Appeal about that.
And could I ask you about paragraph 8 of Mr. Horsford's witness statement, which is page 67?
Paragraph
8. So this was one of the paragraphs that the Court of Appeal referred to.
Yes.
And paragraph 8, Mr. Horsford seems to be saying that in 1993, and your primary case is about an easement of necessity in 1992 or 1993, there was in fact only one access and egress from the public road, and that is via the lower western road and then down the footpath.
No, that's certainly not right, because in my submission, it's clear from Mr. Horsford gives evidence about the creation of the Upper Eastern Road by someone called Ted Stevens in 1982. Mr. Horsford then...
Where do we have that evidence?
There's a judgment by... it's in his witness statement, and there is also the judgment of Mr. Justice Redhead, which is included in the papers. But his case was...
Could you give us the reference?
Yes, I'll get that. So it might be easy to get it on my computer. I'll go to Mr. Horsford's witness statement. Sorry? 87. 87, yes.
It's a judgment. Oh, I see.
Yeah, that's a judgment.
That's the judgment of Justice Redhead, yes. And in the witness statement...
Well, first of all, does Justice Redhead deal with the date of creation of the Upper Eastern Road?
Yes, he does deal with it, because it was by an act of trespass by a Mr. Ted Stevens.
So can you just help us? Where does the judge deal with that?
Yes, I can't read this properly. I do apologise. It's
Very difficult to
almost legible. But when we go to the witness statement, it's also in the witness statement, where Mr. Horsford puts it at 1982.
It appears from page 90, on the 8th of August 1982, the plaintiff got in touch with the defendant and told the defendant that in spite of him, the plaintiff asking the defendant not to cut across the land, he still did so. relates to the creation of the Eastern Road. It seemed to be in 1982.
There seems to be reference
Page
to a full
66,
go.
at paragraph 2, it's about 4 lines, two lines down. There has been no road or vehicle.
Forgive me, what page?
Page 66, my lord.
So is this is this a witness statement?
Of Mr. Horsford, yes.
Yeah, but in which proceedings? In our proceedings?
Sorry?
In our proceedings?
In our proceedings,
Because you were
yes.
showing us a judgment in other proceedings just now.
Yes. And then he says, as a youngster, I had intimate contact with the lands, knew the bearings, there has been no road vehicles until in 1982, a trespasser cut with the view connecting Old Fort to the ground. So, and he then mentions the suit. So the date of the establishment of the Upper Eastern Road was in 1982.
I see.
And then we also know from the evidence.
So one, is this right? This is your position. One needs to read paragraph 8 in the light of that paragraph 2.
Yes.
And paragraph 2 is referring to someone who has created in 1982 a road for vehicular traffic.
And that's, yes.
And that's what we've been calling the Upper Eastern Road, and that runs right down to the far right of the plan,
yes.
page 6.
And there was evidence that there was evidence before.
Just to answer my lord's, if be so kind, it goes right the way down from 281, the Upper Eastern Road, takes you down effectively to the public road.
Yes, it is a direct route to the public road. One goes from 281 to the Blue Government Road that goes directly to Cobb's Cross. So if one were coming from Cobb's Cross, one turns left at Cobb's Cross, by a school, left again, one then drives straight to parcel 100, and parcel 100 is the start of the Upper Eastern Road. And I should add that the first 50, I believe it's 50 feet, I believe it is, from parcel 100 is actually a concrete road as well. And my own friend of yards, the first 50 yards is a concrete road. The other remaining is a dirt road. And again, it's a proper road where 2 vehicles can pass, because that was dealt with in the assault case that Mr. Horsford brought against Mr. Croft and lost. So what is clear is that from the first parcel to the sold off along the road was parcel 100, that's Bert Kirchner. And then in the other case, in the 0641 case, there's evidence there, and the judge makes a finding of fact that in 1985, parcel 143, that's the Tobbit and Van Beek land, was sold to them. So on the one hand, there was a trespasser, but then from certainly the early 1980s, he took the opportunity to divide the estate along the road. So the point I'm making is this is a road that's been in use prior to 1992. So that when in 1992, 1993, Mr. Horsford created parcel 171, the Upper Eastern Road was in existence. And not only that, it led directly to the government road at parcel 100, onto the main road at Cobb's Cross. And so my submission is the only basis upon which Mr. Horsford or parcel 171 could have enjoyed a right along the Upper Eastern Road, or indeed even the Lower Western Road, must have been by way of an easement by necessity, because there was no express grant. and no other form of implied grant back in 1992. And in 2002 and 2005, Mr. Horsford, as owner of parcel 171 in his personal capacity, was not in a position to grant any easement at all. And so the easement of necessity continued. And the contract for sale does not mention that it is being entered into by Mr. Horsford in his capacity as administrator of the estate. It's Mr. Horsford in his personal capacity. So my submission is that there had always been an easement by necessity from 1992 to 1993, and that was not destroyed by any express grant, because Mr. Horsford, in his personal capacity, was not capable of making a grant for the estate.
Again, just for my benefit, the properties that are on the Lower Western Road, between the Lower Western Road and the Upper Eastern Road, for example, 230,
Yes.
would get access to the road.
They all get access to the road, yes. And during the trial, Mr. Horsford's contention was, well, all of them paid extra so they could have access to their land, which is rather a strange situation, because no one's going to buy land and then say, well, also I'll pay for access to it. And except for one person he mentioned, which was Mr. Mullins at parcel 216, he said Mr. Mullins had a separate contract to have access to his land, but that contract was never disclosed in evidence.
Is that 216 or 126?
It's 216, my lord. It's 216. It should be behind. I'll look at my note. It should be behind.
It's just
It
like
should be behind the top.
Oh, got it. Yes, got it. Thank you.
Yes. And so it is a strange situation, and as I mentioned, that it wasn't until 2020 that they obtained a registered right of way, because the chief surveyor took the view that once Mr. Horsford registered parcel 281 without granting any rights of way, everyone was landlocked. And that was the only way that they could reach their parcels.
Can I just be clear on your submission? The red and green marked, which you've marked.
Yes, which Mr. Croft marked.
Yes, Mr. Croft marked. Who do you say owns those areas now?
The red and green,
Yeah.
are you talking about the road itself?
Yes.
The road is still owned by, I accept the roads, the lower road and the upper road are still owned by the estate.
Yeah. But you say only as far as the end of where you've marked green.
Yes.
And then we're into unknown territory.
Yes. Then we're into and that's one of the different.
Well, unknown territory, but your submission is that the evidence doesn't indicate that the estate owns any of the, even if there is an access route through,
Yeah.
it's not owned by the estate.
It's not owned by the estate, yes. But the trial judge didn't just leave it there. He didn't just look at the roads and look at the question of whether or not Mr. Horsford could get access to his home. He also relied on the authority of Dabbs and Seaman, which is an estoppel case, which I've cited in my skeleton, because he was concerned that the respondent had created this parcel and indicated to the authorities that it was bounded by 2 roads without ever saying that they were private roads. And this is what essentially has led to the problem. If he had disclosed that they were private roads, then the Development Control Authority would have insisted that a right-of-way was created, because you cannot create a parcel without having a means of access to it. And so he should have indicated that it was a private road. And it came up, the issue of public and private road came up later on, because your Lordships would have seen from my written case that there was actually, Mr. Horsford relied on the decision of the Court of Appeal to attempt to disconnect Mr. Croft's supply of electricity to his home. And that went to, first of all, Judge Robertson, who refused to grant an injunction, and then it went to the Court of Appeal, and the Court of Appeal granted an injunction until the determination of this case. So if Mr. Croft is held not to have a right to use the Upper Eastern Road, then there's going to be another question about whether or not his electricity supply can remain in place. And there was further evidence about that, because which went to the Court of Appeal, because Mr. Horsford did insist at that stage that he could have the right, an absolute right, to use to have a supply of electricity from the bottom road, which would have cost Mr. Croft thousands of dollars. But when he entered into, when he spoke to the electricity provider, he told the electricity provider that Mr. Croft would first have to pay in order to have a supply of electricity from the bottom road. So far as this decision is concerned for Mr. Croft, it is absolutely vital. He won't have access to his home, and he will not have a supply of electricity, because that will go back to the court. But I mentioned Dabbs and Seaman. On the encroachment, I've explained in my submissions that the reason why the encroachment occurred was that when Mr. Horsford created parcel 171, and when he was drawing the lines down along parcel 171, there was a boulder in the way. And so the surveyor, rather than making a straight line, made a kink in the plan, which meant that if a straight wall was built, then the road would be encroached upon. But the kink is in the form of a triangle, which goes from east to west. So far as the encroachment is concerned, it's not an encroachment that Mr. Horsford can make any use of in any event. What concerns Mr. Horsford, and what is concerning about the Court of Appeal, is that the Court of Appeal accepted the report of Mr. Oliver Joseph and held that the extent of the encroachment was 400 square feet. In the evidence, Mr. Croft disputed that, because he had got 2 surveyors himself who said it was not that figure. And what concerns me is this, is that when looking at Mr. Joseph's evidence, there was simply no declaration of independence which would accord with the CPR at all. And then once the judge decided that, well, actually this should go to the Registrar of Lands, then there was no cross-examination on that issue. So it couldn't have, in fact, the evidence was never tested.
But why don't these issues of fact go back to the court, which will assess the damages in lieu of injunction? Well, there's been an admission by your client that there's been some encroachment. The Court of Appeal hasn't made findings, has it, as to how great that encroachment is?
My Lord, before Mr. Croft obtained leave to appeal from the Court of Appeal, it did in fact go before a master, and the master held that Mr. Croft was stuck by the finding of the Court of Appeal that the encroachment was 400 square feet. And so if it goes back for the assessment, then that assessment will be based on that 400 square feet, unless, of course, the board decides that there should be proper evidence, evidence that complies with the CPR that deals with that issue. But can I say, make another important point?
I thought you said that Mr. Horsford said it was 200 square feet.
No, Mr. Horsford expert actually says it's 420 square feet. The Court of Appeal reduced it to 400 square feet, 400 square feet, but it's in fact less, because other surveyors have come along and looked at it and said it was less, and there was some issue about the pegs, the boundary pegs, having been in the wrong place as well.
Sorry, where does the Court of Appeal reduce it to 400 square feet?
It's in their judgment, so they called it, they didn't say they reduced it, but they said it was 400 square feet.
Paragraph 30 in their judgment, they refer to Oliver Joseph's report showing 420 odd square feet.
Yes, so I do apologise, 420 odd square feet.
But sorry, you said that they...
I thought it had been reduced to 400,
But they describe it as an unchallenged report, but you say that there were two reports to challenge it.
Mr. Croft gave evidence to say that he had got two other experts who had looked at it and did not agree with Oliver Joseph.
Were those experts' reports before the court?
They were not before the court, but that was the evidence before the court, which was unchallenged, that he had in fact got two of his own experts who didn't agree with the figure given by Oliver Joseph.
But why, if he's had an opportunity to challenge Oliver Joseph's report and he's failed to take it, shouldn't he be left with that?
The difficulty was, my lord, is that when Mr. Justice Cottle was dealing with the matter, he decided from the outset that it should go back to the Registrar of Lands.
No, he didn't decide that at the outset. He decided that in his judgment. So the issue was raised.
Yes.
Part of the answer given was Section 17 of the Act. But your client was on notice that he might not win on that argument and needed to have his evidence all ready to
there was also evidence in the cross-examination of Mr. Oliver Joseph, who had conceded that the boundaries were not fixed. And the purpose of Section 17 of the Act and Section 17(4) is to ensure that there are no actions such as this unless the boundaries are perfectly clear. And they were not clear in this case. And that's why it should have gone back to the Registrar of Lands. And then the Registrar of Lands, in her discretion, is entitled, as it were, to say, well, this is de minimis, or I'm going to amend the register to change the boundaries, to fix the boundaries. And that's the importance of Section 17 and Section 18 of the Land Registration Act. And what Mr. Croft really wants is, at the end of the day, is finality. He wants to come home. And one can see that if we have another assessment of damages hearing, it's going to find its way in the Court of Appeal.
What are you asking us to do in relation
to
relation to encroachment?
Make a common sense assessment of this encroachment on land which cannot be used by Mr. Horsford. Mr. Horsford, in the transcript, when he was before Mr. Justice Cottle, suggested damages of something like $490,000 for that small encroachment. Then, when it came to the actual assessment of damages, I think he simply asked for, yes, he was asking for ransom damages. He was saying, well, if you're going to give damages in lieu of an injunction, let's look at the value of the property and see how much it would be paid in those circumstances. So, but it's not. It's.
If the court's against, the board is against you in relation to our making an assessment of damages, then you say it should be remitted under Section 17?
Yes, it should be remitted under Section 17, where a common sense and independent decision will be made by the Registrar of Lands. But I just want to. I'm going over time. My submissions in relation to dabs and semen are contained in my written case, yes. And I would ask the court, urge the court to obviously consider those submissions. And I also emphasise paragraph 14 of the learned judge's judgment, his findings of fact on page 15, paragraph 14, that in fact there is no other way for Mr. Croft to get.
That's his declaration.
Sorry?
That's the judge's declaration.
That's the judge's declaration, but the basis of the declaration is yes, that there's no other way that he in fact he can get to. But unless I can assist the board any further, my lord, those are my submissions.
Thank you, Mr. Carrot. Mr. Simon, we're very grateful to you and those instructing you for your submissions and for the preparation of the papers. The board will take time to consider what advice they will humbly tender to His Majesty.
Much obliged.
Obliged to you. Thank you very much indeed.